I want to welcome you to the University of Calgary and take this opportunity to acknowledge the traditional territories of the Blackfoot and the people of the Treaty 7 region of southern Alberta, which include the Siksika, the Piikani, the Kainai, and the Tsuut'ina, and the Stoney Nakoda First Nations. I would also like to note that the University of Calgary is situated on land adjacent to where the Bow River meets the Elbow River, and the traditional Blackfoot name of this place is Mohkinstsis. I'm fighting a bit of a cold, so. The city of Calgary is also home to the Métis Nation of Alberta Region 3. So welcome. We have a follow-up on the suggestions from last year for topic again, a great speaker with us today. I just want to reiterate that these presentations are available on PDF. I had a number of you ask last seminar as well, where can I get the content? Just know in about 2 weeks, all of this is available on our website, both video and PDFs, and a review written by our students. But if you can't wait that long, just email us and I'll send you a copy, okay? Also, it's important to note that you'll see cards. There's 2 of them. We always ask that you provide your feedback before you go today and let us know how the session went. And this year, of course, we have all our sessions, and you'll notice we're exactly halfway through our season. So 6 events in, 5 to go in the new year. We hope you'll join us for that. But today you're here to hear from Arlene Kwasniak, who is a senior fellow with the Canadian Institute of Resource Law, a professor emerita in the Faculty of Law, and adjunct professor with the Faculty of Environmental Design. Prior to joining the University of Calgary in 2003, Arlene's law practice was with the Environmental Law Center in Edmonton, but that's okay, for 11 years, the last 2 as executive director. She's been the recipient of the Law Society of Alberta and Canadian Bar Association 2013 Distinguished Service Award for Legal Scholarship, and has served as a member and director of numerous non-governmental organizations, as well as advisory committees on all levels of government at the federal, provincial, municipal level. She is part of the Alberta Bar. She has a Bachelor of Science from Eastern Michigan, an MA in Philosophy from Wayne State University, an LLB from U of A, and an LLM from Lewis and Clark Northwestern School of Law. Please join me in welcoming Arlene Kwasniak.
All right, so I'm here to talk about climate change, water adaptation, and law and policy. Now, I come at it from the law and policy side, being a lawyer and a law professor for many years. And I also have to say, I have a bit of a cold as well, and other things, so please just bear with me. All right, so I want to start off by saying what I'm going to be talking about is based on a paper that was published by the CIRL, the Canadian Institute of Resources Law, and funded by the Alberta Law Foundation, which was called Climate Change and Water Law and Policy Options for Alberta. And in that paper, what I did is I identified all of the intersections, or what I call nexuses, between water and climate change and policy, law and policy, and then chose 3 of those nexuses to explore a little more deep. For example, I would first describe what the nexus was. For example, water supply and climate change. What does that mean? And then I would look into what would an ideal legal framework looked like that was totally climate change adaptative and resilient, and then look at where Alberta is. Not expecting Alberta or any other jurisdiction to be there, but just kind of to see where it is, and then to make some suggestions for law reform. In that paper, show a picture of it. I mean, it's more than a picture, it's the real thing, is available from the Canadian Institute of Resources Law over in the 3rd floor of the law school building, or it's available online for free. So I just want to let you know that. And so this presentation is obviously not going to go through all the things that this 85-page paper went through. But what I'm going to do is look at just a few of those nexuses. But first talk a little bit about adaptation and mitigation to distinguish them. And then I'm going to look at a few of the nexuses and some of the adaptation and policy issues, and then talk about 5 steps that a jurisdiction might take to become more climate change adaptive. Excuse me. Okay. So, to get right into it, the difference between mitigation and adaptation. So mitigation, deals with the causes of climate change, like GHG gases. So our mitigation measures that we're taking, the various jurisdictions who are taking measures, are to reduce the human component of contributing to climate change. So that's either through reducing GHG emissions or by removing GHGs from the atmosphere in various ways. Adaptation, on the other hand, looks at the effects of climate change. We know that there are already effects from climate change and that there will be more. And so we as a society should be taking some kind of steps to deal with these. And some of the ones that are being taken in various jurisdictions is to, for example, if a climate becomes warmer and the ecoregion actually changes, and I have a slide that shows that a little bit later on, it may be necessary to change the kind of crops that are growing in an area, or look for more drought-resistant crops, or to adjust stormwater management systems if you have more water on the land than you would without climate change and great extremes. So in this paper, in this presentation and in the paper, I look at adaptation and not mitigation. So this is just a picture of Calgary, and it's going to be the backdrop for many slides. And I know it's a very favorable picture of Calgary. I don't think that picture could actually really have been taken. But I think it was taken, but it was photoshopped a bit. So what do we mean? What are the climate change effects that I'm considering here? Well, climate change will bring more drought, warmer, drier climate, more evaporation, glacier melt, heavier rainfalls on the other hand, more flood events, more variable weather, more climatic extremes, faster runoff into waterways, and therefore more turbidity. So those are the ones that are commonly identified. So then, what are these climate change and water nexuses? Well, these are the ones that I identified in the paper, and I'm not going to go through them all right now, although I will touch on all of them in at least very briefly in this presentation. But what I'm going to do is just focus on a few of them, and those are the ones that are in yellow instead of pink. So we're going to start with less in-stream flow because of warmer temperatures, drought, and evaporative losses because of the warmer temperatures. And I want to start with in-stream flow because in-stream flow is really at the heart of the nexuses between climate change and water. Because so many of the other effects are related to in-stream flow. So we'll start off with the question, what is in-stream flow? And by in-stream flow, I mean really it's just water that's flowing in a water course. But the harder question is, what our in-stream flow needs? How much water is needed in a water course at a particular time of year, because flows are always seasonal. Well, in order to answer that question, because that's what the water managers are all asking, I'm going to use the Brisbane Declaration on Environmental Flows definition for in-stream flow needs, which is the quantity, the amount of water, the timing, and the quality of water required to sustain freshwater ecosystems and the human livelihoods and well-being that depend on these ecosystems. So we're not just talking about water for fish and the aquatic habitat, although that's the core of it. We're also talking about the needs of humans who rely on water, surface water from rivers. So we're talking about all the various uses that we make of water for domestic use, municipal use, energy, agriculture. So as I mentioned earlier, in-stream flow is really central to the issues respecting climate change and policy choices and adaptation. And I'm just going to go through some of these to show how they just affect all of them. So less moisture, more variable weather, and wildfires. If there's certainly less moisture in areas where moisture comes from a watercourse, then certainly the moisture in the soil will be affected. Less in-stream flow, I'm talking about less supply, more water use conflicts, government strife, and litigation. In a little bit, I'll be talking about how water licenses are given out in Alberta. But if there are less supplies, less water supplies, there may be conflicts between water users because not everyone will have the right to use that water. And then the government, there'll be government strife because it's the government that administers water rights. And with climate change, as it becomes, as we have more drought and less supply, we can have more water use conflicts. And it will likely come to litigation. Aboriginal water entitlements, I'm going to spend a little more time on, so I'll skip that for now, as well as the next one. Then we have a greater reliance on groundwater. In the South Saskatchewan River Basin, for example, where we all live, which is roughly between Red Deer and to the end of the Alberta, there is a moratorium on surface water licenses. The basin is closed, the South Saskatchewan River Basin, or most of it, to new water licenses except for a few exceptions. And so if a person wants water, they have to find some other way to get it, either through getting a groundwater license or getting it from some other source. But and as it turns out, we know a lot about groundwater, but we don't know, quite as much as we should. And groundwater is more connected to surface water than we used to think. And so we can have groundwater that's impacted by aquifer depletion can certainly impact surface water and in-stream flow as well. Bacteria growth and rise in problems with meeting interjurisdictional agreements. Okay, just very briefly, Alberta has an agreement with Saskatchewan and Manitoba to provide 1/2 of the natural flow that would naturally flow from the rivers that in Alberta into Saskatchewan. And natural flow means the flow of the water if you take away all of the human intervention, all the water licenses and the infrastructure. And though Alberta has been able to quite handily meet those agreements with climate change and with further water demand in the future, it may be more difficult. Bacteria growth and rise in waterborne diseases. There is a lot of literature out there about how climate change impacts water turbidity, which can result in more waterborne diseases. Energy impacts, I'm just going to say that the energy industry holds about 10% of the issued water entitlements in the province. And so obviously, if there's a water shortage, the energy industry is going to be impacted. Transportation, it's quite the same. Transportation, river infrastructure, for example, can be impacted by in-stream flow, either too much or too little. I'm going to talk specifically about eco shifts, ecoregion shifts, so I won't mention those, or really the rest of these right now. But the point I'm making is that in-stream flow, how much water at what rate is flowing through a water course and of what quality is really core to the larger issue of climate change and water and policy. Okay, so am I moving here? There we go. Okay, so with respect to in-stream flow, just to show that we already have a problem, with too many water licenses issued. I'm showing you this slide, which shows the license allocations in 2010 by basin. So the province is divided up into river basins. And in this slide, although it's I don't have a pointer, apparently that will work. If you look at the kind of purplish pink areas, that says more than 100%. What that means is more than 100% of the allocatable, well, actually of the water, has been allocated. Now, there could be some return flow, so some of that might come back, but still, that's more than 100% of the water has been allocated. And so unless there's some way for government to get back those allocations by conditions on licenses or something like that, in a time of shortage, there could be really extreme issues with respect to in-stream flow, real problems. And then the kind of the purplish pink one before that is 80 to 100%. So, and there's a lot, and you're probably noticing that a lot of this is in southern Alberta. So we already have some serious issues with low in-stream flow. And this is just a number of statements made by or for the Alberta government regarding lack of flow. I'll just read the bottom one. It says, managing the South Saskatchewan River Basin at this time to meet in-stream flow needs to sustain riverine processes and associated ecosystems over the long term is judged not possible because of existing allocations. So this was from maybe around 2006 or so. So when the government admits that it's not possible, yeah, you know you have a problem. The other slides, the one on top with all the little purple dots just shows the allocations, and the one on the right is a very recent slide from the Alberta government, which shows that we have water shortages in various places in southern Alberta. So the adaptation questions one might ask are, okay, so we have water shortages, we have problems with in-stream flow, managing in-stream flow. What do we do about it? How can we adapt to this situation? What policy changes do we need to make? Well, I'm going to borrow from my paper here and for this one topic, and say and describe what I would think would be an ideal climate change adaptative water management framework. One of the first things that would have to be is flexible to enable adaptation. You can't change in order to adapt to a situation, or have it in your toolkit that you have to change, like change how a license is going to operate, unless you have a flexible system. And also, the water distribution rules would enable those with the most need to receive water without compromising other users. And so if it's the environment, for example, that needs the water, the rules themselves would have to permit that in some way or the other. Also, I would say would have to incorporate Indigenous water rights, which I'll be talking about in a minute. And it should have an array of tools for getting back water to restore and protect in-stream flow needs. Like I said, some of the rivers in the South Saskatchewan River Basin are over-allocated or fully allocated. So that means they're privatized in some ways, even though they may not be property rights. the water licenses. There's no doubt that they're considered that way, and that moreover they mean a lot economically and in lots of other ways socially to the water rights holders. And so you have to, in order to get some of that water back to protect the basic system, you really need the cooperation of the water rights holders, and I'd say, you know, the watershed stakeholders in general. I think the system would be a system that operates on a watershed management basis, because that just makes sense, and would manage groundwater and surface water conjunctively together, because they, in the world, in the real world, operate conjunctively, and also be a part of a comprehensive climate change adaptation plan and strategy. Well, to see how Alberta measures up to that ideal, I think we have to look and see how Alberta regulates its water rights. So I managed to get Alberta legislated water rights down to 5 slides, and I'm very proud of that. I guess I should first say that the water in our legislation is said to be owned by the government, and then the government gives other entities besides itself the right to use water through water entitlements that are legislated. Okay, and water has been legislated since 1894 and is now legislated under the Water Act. Water acts are based on what's called prior allocation. That means first in time, first in right. So the earliest allocated water licenses, the most senior licenses, have the right to the full entitlement under that water license before any more junior license. That would be, but that only operates in times of shortage. So otherwise it's just business as usual. There are also various provisions in our water legislation that I think are pertinent to this topic, and one of them is use it or lose it, that there are all kinds of incentives in the Water Act to use the water under your water allocation, or else you could possibly lose your license if you haven't used it for a long enough period. And there's very little provision for flexibility, fairness, or adaptation, because the purpose of a water license is really irrelevant, you know, once you have it. And there's nothing in the Water Act that says, you know, municipal uses have priority over commercial uses or anything like that, or in time of shortage, water will be distributed in some fair way. It's just really the priority system. And even though the new Water Act was meant to, which became law in 1999, was meant to bring in more flexibility and more maybe social, environmental type considerations, the core of, you know, what's been there since 1894 just moved right into the new legislation. So how does Alberta's water management framework fare with respect to the ideal? I'd say it's not flexible. The water distribution rules are pretty hard, and it's first in time, first in right. There is a provision for water users to agree amongst themselves to share water, but there's nothing in the legislation to require that. It does not provide for vulnerable communities or incorporate Indigenous water rights, or provide for the aquatic environment receiving and retaining water. It has some tools to get water back into the system, though I don't think, and I think generally it's not thought that they are adequate, at least in places where the water has been largely privatized. With respect to adaptive management again is the kind of would be like a condition in a water license that says, you know, if environmental conditions change, then you must adapt to those conditions by, for example, using less water. There are some adaptive management conditions, especially in newer licenses, but they're the ones that, and there are some actually in really old licenses as well, but it's not clear whether they're enforceable And so I don't know if they would actually be very useful if the government tried to enforce them. We partially operate on the basis of water management plans. We have water management plans anyway, a few of them. Recognize and facilitate a variety of sources to preserve in-stream flow. What I meant by this, our in-stream flow would be less impaired or would be less of a worry if we went to other sources of water for our needs, like water reuse, the kind of thing that WaterSmart is really into, or using desalinated water or produced water. And I think the government is partially there. It's certainly looking at water reuse and using produced water and the like, but it's taking very shy baby steps in that direction. Conjunctive management, again, on some of the government websites, you'll see that they strive to do that. But when you have licenses that are issued, surface licenses that are issued at different times from groundwater licenses, I think it's very hard to manage them as a unit. Comprehensive climate change adaptation plan, no, we do not have that. The next topic, the next nexus I'm going to touch upon is Aboriginal water entitlements. This slide shows, it's an article from the Globe and Mail from last fall. It says, First Nations seek compromise on water rights. It was actually a very interesting article. It was talking about the Ermineskin Cree Nation, Samson Cree, and Kainai First Nation, who approached the government saying that they wanted senior water rights because the government's position is that in order to legally use water on reserves, First Nations need a water license, just like anybody else. It's as if when the reserves were set aside and the treaties were made, the land was given in trust to the Aboriginal people of that treaty, but not the right to use the water. Now, I know, to me that sounds ridiculous and completely counterintuitive, but that is the position that the government has taken. It's possible that Premier Notley might take a slightly different position, but now that is all just under discussion. So First Nations are seeking a priority, a senior priority, since a lot of the reserves were settled even before 1894, most of them, and even before that they were the users of water. So they say they have a prior water right. But this has not been at all settled, and it will probably take a court case to settle it unless there can be some agreement with the Alberta Crown. So the adaptation question then is what can be done to adapt to this nexus? Because as water becomes more scarce with climate change, then the issue of Aboriginal water rights is going to become more critical. And then how should law and policy govern the nexus? Like right now, Aboriginal water rights are not recognized. So my advice would be yes to settle this now before it really comes to a head and before there's a court case. In the States, there was a court case which found for the Aboriginal band, and they found that there was a reservation of water at the date of the reserve for their purposes for the reserve, which in that case, which were irrigation and a few other purposes. So the next one I want to talk about is changes to channel form, riparian areas, property boundaries, and impacts on river infrastructure. Well, I'll just talk about a few of these. Now, changes to channel form is something that happens because of various events, like if you have extreme climate events and you have lots of water rushing into a river, it can cause a lot of turbidity and sediment to be rushing down a river and cause changes to the channel form, the geomorphological aspects of that channel. And it happens, I mean, it's really common in southern Alberta for rivers to change their course and to meander, like physically meander, from one place to the other. And the literature would say that with climate change, you're going to have a lot more of this and a lot more quickly than we have seen in the past. And this, the other aspect of this I wanted to talk about has to do with property rights, where you have rivers changing their course or changing their location, and you have people who own property right up to the river's edge, where you have that kind of situation. So they're riparian owners; they own the property right up to the river edge. Then they're riparians, and one of the benefits of being a riparian, and I guess in one of the detriments, is that the benefit is that if land is added on to your property slowly and imperceptibly because of the movement of the water, either by exposing more land or through sediment and building up more land is added on. Well, if it's slow and imperceptible by this common law doctrine called accretion, your property has just increased. And you can go to land titles and get your land title amended to show that. But on the other hand, if through slow and imperceptible movement your land erodes slowly, you just lose that property, and that's all there is to it. So what does this have to do with climate change? Is that climate change might involve what are called avulsive events more than these accretion events. And avulsion is another common law doctrine, and that one is if the movement of the water is not, and the addition to the land or the taking away from the land is not slow and imperceptible, but comes from some more quick events, then there is no change in ownership at all. So you can have, if a big chunk of your land is pulled away by some climatic event and then attaches to the land across the river, then you now own land across the river, and the guy across the river doesn't get that land. So it can be very, very, very important to the landowners. I just put up that little map in the corner there is of the Highwood River, and it comes from a somewhat of a famous case among very few people. It's called Robertson and Wallace, because in this case the Highwood River just did that. It was moving all over the place. There was a land that broke off from other land, and all kinds of fights through the years as to who owned what. And in this case, the court found that some of it was accretion and some of it was avulsion, and so like one owner actually did own land across the river because it got there through an avulsive event. So what adaptation questions, what can be done about this? How should law and government and policy govern the nexus in adaptation? I published a paper a number of years ago now where I recommended that our Land Titles Act be amended to recognize all of the little tricky accretion questions and avulsion questions and say what happens. Because, I mean, this isn't the only situation. There are all other kinds of tricky situations where you end up with, because of accretion, you have overlapping titles where more than one landowner would own land. And so that this should be dealt with now. And I think with climate change effects here already and more to come, this would be a good time to do it rather than just be leaving this to the courts. The next yellow one is stormwater management at all levels, domestic, municipal, and other. Okay, stormwater management is really a wonderful thing, I think. You know, before I wrote this paper, I knew a little bit about stormwater management, but I didn't know, you know, at how many levels it was happening at all times. You know, a person can look at a landscape, and if you look at it through a stormwater management lens, you know, you might be able to, you know, see why the water is moving the way it is because of such things as, you know, gutters and drainage, drainage facilities and swales and all the other stormwater management apparatus and tools. And but the adaptation question is, you know, what with climate change, what we're finding is that, you know, what used to be for example, a 100-year flood or you have some infrastructure, stormwater infrastructure that's built for a 100-year flood, may not withstand that same kind of weather, you know, much less than 100 years, like every 20 years or every 5 years. And we've seen various places, especially in the United States, where otherwise viable stormwater systems have completely failed. And throughout Canada, there are cities which are taking part of stormwater management climate adaptation plans, which include, you know, not only you know, concrete and other man-made materials, but also using such things as wetlands and low-impact development ways to deal with stormwater, such as rooftop gardens. And so this is another thing that is happening, and certainly happening a whole lot in the United States, notwithstanding the Oval Office, and it is happening here in Canada too. But I think we really need to get on with it. There's a legal paper out there that I heard at a conference that I went to recently that said that provinces and states should require all municipalities to revise their stormwater management plans and to, you know, make the adaptation changes that need to be made. The last particular thing I'm going to talk about are ecoregion shifts, impacts on wildlife and habitat. Mainly I'll talk about those, but with this I think we should be thinking about other things as well, like declining soil moisture, pest survival, different pests. If you have a different landscape, you're going to have different pests, forest, grassland, and crop impacts, and also impacts on conservation lands. This is from the Alberta Biodiversity Monitoring Institute in Edmonton, and it shows 3 climate change models. The first one is the present, which is 2015. The second one is a cool model, which shows an increase of 2.5 degrees centimeter in mean annual temperature. And the third one is a hot model, which shows an increase of 6.5 centigrade and significantly drier conditions. And the colors, I don't know if you can read them, depict different land ecotypes. So I'm just going to look a little closer here. Oh, well, I can't read them either, but the yellow I know is grassland. And then the yellow is grassland, and then I think the brown and going into the greens the brown is parkland. And anyways, the whole key is on the left. But the important thing is what you see is that, you know, whole regions of ecological changes. And so the like the grasslands in the yellow and the present go all the way up to the middle of the province on the hot model. And parkland has completely disappeared. Now, this, of course, raises all kinds of policy and adaptation issues. I mean, some of them I think are really, really, really hard to deal with, but I think our lawmakers and our so-called stakeholders, public, everyone, have to put our heads together and figure out what we want as a society. For example, what do we do with endangered species? And, do we fight to the very end? When their habitat is now disappearing because of climate change and not just because of development? Or do we decide to bite that bullet? Do we, what do we do about species migration, where species are migrating to other places because of climate changes? There are, in the literature, all kinds of things about assisted migration, where you put whatever in trucks and drive the grouse somewhere else, or try to get them to establish habitat elsewhere, or make wildlife paths, for example. One of the things I'm very interested in and have been for years are conservation lands and conservation easements. You probably all know what a conservation easement is, but I'll just say quickly what it is. It's an agreement between a landowner and someone who is able to hold a conservation easement, like the government or various land trusts, to conserve land, and it's always for specific purposes, and they're in perpetuity for the most part, but it can be for a term. And then this conservation easement is an interest in land, and then the land has to be used in accordance with that conservation easement. The question is, what happens if the object of a conservation easement is to preserve certain species, which, because of climate change and changes in ecoregions, no longer habitate that land? Is the conservation easement thereby voidable? There are some real questions. What about government conservation lands? If lands are set aside for particular purposes and then they no longer, those purposes are no longer relevant. And so for adaptation here, I think what we need to be doing, not just governments, but land trusts and and society generally, stakeholders have to be really thinking about what we have done to preserve certain species or certain ecoregions, and then think about do things change if the ecoregions change? There's a lot of work being done on this in the States, or at least was done, and I think we should be looking at that as well. Okay, so finally, and I don't even think I got my 5-minute sign yet, so I'm very proud. This is my last slide, and it's just about getting to adaptation. What adaptation? What I did is just showed a lot of connections between water and climate change, and raised a few policy issues, and identified a few things that could be used to, or might be needed in order to adapt to climate change, and raise a few policy issues. But if a jurisdiction were really serious about doing this, what it would have to do is, first, do a risk assessment of the water climate change nexus. Now, whether this is at a municipal level or a larger level, or even a non-governmental level. And then identify and prioritize climate change adaptation actions, and create a climate change adaptation plan. In the United States, many municipalities and states, about a third of the states have climate change adaptation plans. And they're very easy to search in the states, at least they were when I last looked. But in Canada, it's harder to find this information, but I did find that it's happening throughout Canada as well. There are a number of municipalities that have climate change adaptation plans. Alberta is, started, it's been very, very forthright with respect to mitigation, but not so much with adaptation. It has been moving a little bit in that direction, but certainly not as much as with mitigation. It's harder to find these, but there are some out there. And then you have to review your laws and policies and see and try to figure out where they would be, what they would be like to facilitate an adaptation plan. And this would be done at the same time that you're drafting your plan, of course. And then I think you just have to face those conundrums, those really hard questions, those hard issues. I have a quote here from the Premier, in fact, where she talks about our 1894 water law and how difficult it is to deal with that when you're looking at something like how do you acknowledge Aboriginal rights now? And I think you have to face those conundrums and then just move on and move through them and bite that bullet. And then finally implement the plan. That's it. Thank you.
Awesome. Thank you.
Hi, Arlene. Thank you for coming to present this. And David, thank you for organizing this. I know you have a committee or whatever. Do you have a slide or research of all the First Nations in Alberta that use the water and that have water use in this province?
Okay. I think all the First Nations use water, for sure. There are, I understand, 91 water licenses that have been issued. So there's way fewer licenses issued than First Nations who use water. And I understand a lot of those water licenses were sort of applied for under protest, in the sense that, we need the water, so we're going to apply for a license, but we are not therefore acknowledging that we have to do that. And the government has offered to issue surface water licenses in the South Saskatchewan River Basin to First Nations to try to help satisfy what the government thinks is required. But the First Nations, rightly I think, say, no, that's not good enough because these will be really junior licenses. So in a time of shortage, that means the senior licenses will have the first right to use the water, and the junior licenses will be cut out unless a water sharing agreement can be worked out amongst the various users. And from at least the newspaper articles I've read on this, there's concern that such an agreement will not be worked out in every case.
Thank you very much for your talk. The question I have is there any way that we could utilize an adaptive process to slow the runoff? When there's a runoff, we could slow that down, I guess similar to the Old Man River, of where they dammed it somewhat.
I've heard that being done. In fact, it has been done in, I believe it was either Manitoba or Saskatchewan, where small dams were built in order to slow the velocity of the river in order to deal with waterborne diseases. And because turbidity is associated with the waterborne diseases. So yeah, that would be, that's one way. It can be done, but I mean, of course, you need a water approval under the legislation. You'd have to make sure that any property rights that were affected were dealt with in some way. It might affect downstream users if you put in some dams upstream. So there are a lot of issues with doing that, but that is one of the ways that adaptation has been dealt with.
You mentioned the DAF situation where the senior licenses take everything. Could you actually give us an example of a real event where the junior ones were literally cut out?
That's a very good question. So the question is there a real example where there's been like what's called a call on the water by the seniors? Now, it happens all the time in the United States, okay, in like New Mexico and all of this, Arizona, all of the states that have a similar water rights system. It's a little bit different, but for practical purposes, we can say they're pretty much the same. And there are calls where, people are watching the water flow past their farm and they can't have it because the senior guy is downstream. In Alberta, to my knowledge, there has never been a call. That doesn't mean there won't be. There was I think it was in 2002 that it came pretty close because of drought, that the juniors would be cut off. But then the various users entered into a water sharing agreement, which they are unable to do under the Water Act. And I don't know if money passed hands or anything, because that's not the business of the government. They don't see it as their business anyway. And they had this water sharing agreement so nobody would be cut off. But it's interesting, in other jurisdictions, water sharing agreements, or what's water sharing is part of the law. Like in Australia, if there's a shortage, and then there's a forced, I guess you could say, water sharing. So you share the shortage. And that has been advocated in Alberta. It was certainly advocated when we were in this last round of water reform.
So we have time for one more.
Hi, thanks. Just a question about, you mentioned that, I forget what article you cited, but you said that the long-term sort of sustainability of in-stream flow was more or less impossible in some regions. And I was just wondering, so are there no expiry dates on any allocations then, or is it all just up to when the government decides to give those allocations out and then subsequently take those allocations away?
So the reference was back to this slide where it was acknowledged that we just can't get our in-stream flow requirements in some places in the South Saskatchewan River Basin. I mean, I would hope we could, that we could get what are like privately held in-stream licenses and let the market, by something like land trusts, except they're water trusts. And maybe that would help, because the tools that are in the Water Act right now I don't think are sufficient. But the question was, do these licenses expire? Well, the answer is, before 1999, which is when the new Water Act came out, the licenses did not expire. They had no expiry date. I mean, they could have one, but on the whole, they will not have an expiry date. But after 1999, they do have an expiry date, but they're pretty much automatically renewed.